Okay.
And we are now recording. Terrific. Well, thank you so much, Jonathan, for asking me to do this workshop for Collaberex. I'm thrilled to be doing it. I just want to warn everybody, this is just the tip of the iceberg, right? And there is a lot of information here, a lot of content. I will be sharing my slides with everyone who registered. So, you know, if you want more detail. And of course, you can always reach out to me. But yeah, we're going to talk about what employment law did you break lately. Now, I'm not going to cover all the employment laws. You saw the list, and I'll get to that, what we actually are going to cover today. But first, let me get the boring legal stuff out of the way. This presentation is for informational purposes only. It's not offered as legal advice. It's not intended to create an attorney-client relationship with any of you. And I recommend you consult with competent local employment counsel to determine how these matters may affect you or your business or your clients' businesses. So, what are we going to cover? Well, we're going to talk about the proper way to fire employees, if you have employees, understanding the difference between an independent contractor and an employee, and why it's so important you get this right. And I suspect many of you do use independent contractors, or your clients do, or you yourselves are independent contractors. How employers can legally stop employees from poaching clients and other employees. That's topic 3. Topic 4 will be the do's and don'ts of social media in the workplace. 5 is what employers need to do to accommodate employees with disabilities. And 6, how employers should investigate a discrimination or harassment claim. Now, like I said, this is mainly focused on employers, but many of you, I believe, have employers as clients if you yourself don't have employees. And a lot of the information is useful for employees too, as well as independent contractors. So, just sort of have to, look at it from a different perspective, and I'll try to point those things out as we go along. So the first thing I want to know, and if you could put it in the chat, and Jonathan, you'll let me know how many in each category. Who are you? Are you an employer, an employee, or an independent contractor? And who are your clients? Are they employees, employers, employees, or independent contractors? So you could just list, me, employer, or me, A, B, or C, and clients, A, B, or C. That way, Jonathan, if you can, and then see what people put in the chat, just so I have a sense of how many of you are in each category, so I can hopefully, pivot a little bit here and gear it to your interests.
Okay.
Give you a couple minutes to do that, but not too long, because we have a lot to cover. As I notice, the moderators at the debate say, we have to move on. We have a lot to cover.
Yes. Okay. So here we go. We have one employer, employer, clients, all the above.
All of
We
the
have,
above.
yes.
Okay.
1A and C. So employer and I don't know what C was.
Independent contractor.
Independent contractor, clients, employer, and employee, employee, all the above.
Okay.
It keeps going on. So
Okay. You know what?
there are a
Good.
bunch of employers and a bunch of people that are independent contractors, or their
Okay.
clients, or both.
Right. That's great. That's great. So this should be of interest to everybody then. I'm good. That makes me feel better. Good. So the first topic, how to fire employees legally so you don't get sued. Firing an employee can lead to legal repercussions if it's not handled properly. Understanding the essential steps to take can really help protect your business or your client's business from potential lawsuits. I'm going to explain what to do, how to do that. So first off, you want to maintain detailed records. You want to keep complete detailed records of performance evaluations and any disciplinary actions, including violations of workplace policies, and make sure you note dates and witnesses of all the incidents that are relevant. Document all communications that you have with the employee regarding any performance issues or misconduct, and put that in their personnel file, and ensure that all records are accessible and well organized, so that, if an attorney needs to look at it on your behalf, or where there's some potential legal claim or a legal claim, that you've got your records, readily available. You want to communicate clearly to the employee. I love this graphic that my assistant did. Um, Clearly and simply, when you're terminating an employee, clearly and simply explain why the employee is being let go, but don't engage in a debate. That this is not the time for a debate. Today's your last day. We've decided to let you go. Here's why. We're not going to debate this. Include key details such as, is it today or is it a week from today? Depending on who it is and how much you trust them and what their level is. Are you going to pay them severance and any next steps in terms of cleaning out your office, et cetera. Make sure it's a private conversation. You want to ensure confidentiality and also dignity. You don't want to, do this in front of other employees. And make sure you have written documentation and a summary of the meeting. It's always good when you can to have someone else, at least two people, three people at the meeting, the employee, whoever's communicating the employment termination, and then a witness as well, if possible. And that would be the person who would take notes. Offer severance if you can, particularly if it's an employee in a protected category. What do I mean by protected category? If you don't know, it's someone, well, these days it could be probably almost anyone, but it could be someone who's either young or old, right? It used to be just 40 or older. Now it could be someone who's young too, particularly in New York and New Jersey. Someone of a different race, a different nationality, a different ethnicity from, white American, right? Women are in protected categories. Someone who's pregnant, someone who has a disability, and someone who has a different sexual orientation than heterosexual, or gender identity. So those are the basic protected categories. There may be more. Outline the severance terms clearly if you're offering severance, including the amount, any conditions attached. And the most important condition when you're paying an employee severance is to have them release any potential claims against the company and the principals of the company, and any benefits that you may want to offer that you're going to continue. For example, if they're on company's healthcare plan, typically employers offer, let's say they're offering 3 months severance, 3 months continued healthcare coverage. The employee pays their portion, the employer pays their portion. It would be typically would be either COBRA or New Jersey continuation coverage, but so that 18 months starts running. But the company really should provide some of that. Outplacement services, again, if the company can afford that, or some type of access to job resources as part of the package is a good faith thing to do. And obviously ensure, I say obviously, maybe not everybody thinks it's obvious, but ensure that severance agreements are in writing, that they're signed by the employer and the employee, and that they're legally compliant. There are all kinds of rules about that, which I'm not going to get into. We don't have time for that today. If you're doing a mass layoff or even multiple employees, more than one, you want to make sure you're not discriminating against people in protected categories, that there is no disproportionate impact on people in protected categories. So you want to analyze the workforce demographics. Typically this occurs when there's restructuring or, costs need to be cut. And we all know that one of the highest costs of doing business is paying employees, right? But it does, if you have a good team, it does pay off. Use objective criteria so that you're not discriminating against people in protected categories. Have your severance formulas be consistent for all similarly situated employees. Make sure, look, it doesn't have to be the same formula. It could be anywhere from 1 week per year of service to a month per year of service. That's a typical range. But sometimes there's like a 2-week base, and then, higher level people get more, or you just give 2 weeks to everybody, or 2 weeks to lower level employees and a month to higher level. I mean, that's a managerial decision that you can make, but just make sure that VPs are all getting the same package, based on their years of service, of course. When designing layoff strategies, and involve legal counsel, and local legal counsel, to make sure that you're compliant with employment laws, and make sure you document all your decisions so that if you have to justify them later on, if it's challenged, you have that documentation. So now it's time for a little poll or a quiz. See what you've learned so far about laying off employees. You've just completed a performance review for an employee who has consistently underperformed. And that is a good reason to lay somebody off, by the way. After several documented meetings, providing the employee with constructive feedback, that's good. That was done. You're considering terminating their employment. Which of the following steps would you take to avoid a potential lawsuit? So just put your answer in the chat, and Jonathan will read it off. A, maintain detailed records of the employee's performance. B, during the termination meeting, allow the employee to debate the reasons for their termination. C, offer a severance package even though it's not required by law. D, offer severance pay without requiring the employee to release potential claims. And E is all of the above. So let's see what you learned.
Okay. We have A, AC, 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 A definitely, C maybe. You can't hedge here. A and C. Okay.
Oh, you can hedge, and I was going to hedge. Yeah, I think, well, those are great answers. So we have a very attentive audience here. Good. A definitely, and C, yes. It depends on the circumstance. If they're not in a protected category, you don't have to offer severance. Even if they are, you will risk a lawsuit, even if that's not the reason you let them go. And look, the record keeping is probably the most important thing, because that will, that way you can justify the employment termination if it is challenged. All right, on to the next topic, and independent contractors versus employees. Understanding this distinction is crucial for businesses to ensure compliance and avoid liabilities. There are a couple different tests. Under federal law, if your state, which doesn't apply to New York and New Jersey, and I'll get to their tests in a minute, but if you're in a different state, in a state other than New York or New Jersey, and the state does not have what's called the ABC test, which I'll explain in a minute, you need to apply the 6-factor federal test. And these are the factors. And you'll see a lot of these factors overlap with the other factor tests that I'm going to talk about. The nature and degree of control that the company has over the work. So I'm going to explain these in detail, and then I'll go over them more quickly when I talk about the other tests. Nature and degree of control. What does that mean that the company has? Well, over the work, it means you set the workers' hours, you set the days they're supposed to work, you control their actual work, how they do the work. Obviously, there has to be some oversight, even with independent contractors, but the more you control what they do, the more it's likely that they would be deemed an employee. And also if you're determining their pay as well. The extent to which the work is an integral part of the business. So if you're a company that makes widgets and you're hiring someone as an independent contractor to make those widgets or to be part of that manufacturing process, that's an employee. That's not an independent contractor. If you're hiring a bookkeeper and you're not in the business of bookkeeping, then that could be an independent contractor. I have a bookkeeper who's an independent contractor because I'm an attorney. I offer legal services, employment laws, law in the realm of employment law. That's not part of my business. But if you're an accountant or a bookkeeper and you hire a bookkeeper, you better hire them as an employee. Um, Whether the worker has made a significant investment in tools or has incurred unreimbursed expenses. You do not want to reimburse expenses to independent contractors. You may think it's the right thing to do, it's a nice thing to do, but that really, again, weighs on the side of them being employees if you're reimbursing their expenses. They should be incurring their own expenses as independent contractors. They should be using their own equipment. You shouldn't necessarily be providing them with a laptop or a phone or anything like that. They should be working, minimally in your office as well. Um, Workers' opportunity for profit or loss, that's a little tricky, but it has to do with, can the worker bring more business to your company and make more money? Are there incentives for that? Now that's often employees too, but it's more so, is the worker in their own, I think that's more about, is the worker in their own business, right? And then yes, they can determine who they work for and how much money they make. Um, Permanence of the working relationship. It's a factor, but it's not a determinative one. Just because someone's a temporary employee doesn't mean they could be an independent contractor if they're doing the same work that an employee would do. But again, if they're not long term, if they're temporary, if they're doing work that's really outside the integral part of the business and you're not paying their expenses and you don't have a lot of control over their work, then they could be an independent contractor. And finally, worker skill and initiative. If this is something really, really specialized that you need in your business, but it's not your, again, the normal course of your business, that could be an independent contractor. Like I said, a lot of these factors overlap a bit. Then there's the catch-all, which is totality of the circumstances. It's a nice legal term that judges like to use. It means, look, we're not going to look at any one factor in isolation. It's really cumulatively, how many weigh on the side of employee or independent contractor. So let's go to the ABC test, which is the test in New Jersey. There are only three elements, so it makes it easy in some ways, but it's also that all three elements have to be met to classify a worker as an independent contractor. So the worker has to be free from the control or direction of the hiring entity. The service performed must be outside the usual course of the hiring entity's business, and the worker must have their own business, be engaged in an independent trade or occupation that is related to the service. So if you're hiring a carpenter who has their own business, if that carpentry is not your core business and you're not directing how they do the work, then they could be an independent contractor. But if carpentry is your core business and you're hiring them, that they would have to be an employee. If you're, you know, like I said, my bookkeeper has her own independent trade or occupation related to the service she provides to me. But let's say somebody on the side does something else completely different. They're a carpenter working in your business, but they also teach, give piano lessons. Well, that doesn't matter if they're not, unless you're a piano studio, which I actually had a client who's a piano studio, that wouldn't fly. So failure to meet any one of these criteria can lead to what's called misclassification, which can result in steep penalties if you get caught. And it's usually the Department of Labor who comes in and investigates these things. Recently, a restaurant in New Jersey, I think it was in the last year or two, incurred $1 million fine for misclassifying their employees as independent contractors. So beware. New York.
Alex, should we leave the questions to the end so we get them all done at the end and
Oh,
put your
yeah.
questions in the chat as we go along?
I think I'd like to leave them to the end so I
Sure,
can
whatever.
gauge. I may have to speed things up because I know we're almost at the half-hour mark.
Okay.
But yeah, let's see if we can leave them at the end. That would be better. Thank you.
Sure.
For some reason, whoops, let me go back. Sorry. So New York's 12-factor test. I'm sorry, this slide is off the screen a little bit, at least on my screen. In New York, an employer-employee relationship may exist if the company, and there's 12 factors here. And again, you'll see a lot of these overlap. I'll just go through them very quickly. If the company chooses when, where, and how the worker performs services, that's an employee. If the company provides the facilities, the equipment, the tools, and supplies, that's an employee. If the company directly supervises the services, sets the hours of work, requires exclusive services. This is something that didn't come up in the other tests. You don't want to have a non-compete agreement with an independent contractor, at least not in New York, because that's restricting them from working for other companies. And then that's an employee. You can do that now with employees. So I'll talk about that a little later. But not independent contractors. The company sets the rate of pay, requires attendance at meetings or trainings, asks for oral or written reports. Well, I think that's a little questionable. Again, there are 12 factors and they all have to be weighed. It's again, I believe, a totality of the circumstances analysis. Reserves the right to review and approve the work product. Again, I think that's a little, a little along that fine line, because obviously you need to be able to review and approve anybody's work product who's working for you. Evaluate job performance, in a formal way, requires prior permission for absences. Well, yeah, I mean, look, here's a project, get it done, right? That's the independent contractor relationship, not employer-employee so much. And has the right to hire and fire. Obviously, you're not, again, you're on a contract with an independent contractor. It's not a hiring or firing situation. What are consequences of misclassification? Well, pretty severe penalties, tax liabilities, back taxes, penalties, interest, legal claims from workers seeking unemployment or workers' compensation benefits, fines imposed by federal and state agencies, loss of credibility with your employees, and negative publicity. So just to emphasize, it's something you really need to, be aware of on both sides.
All right, I have a question. Can everyone see the slides?
Yes,
Okay.
Oh, good. Okay.
Yeah, I
Can you
just
not
wanted
see
to
them,
make sure
John?
because I got Rachel, you can't see the slides?
Oh, is somebody not
Now
seeing
she
them?
can. Okay, good.
Okay. All right,
Just
good.
want to make sure.
We want you to
Okay.
see them. I mean, I'm basically, giving you
Yes.
the information, but it sometimes helps to be able to see it too. So how do you avoid this? Well, you want to conduct regular reviews of your worker classifications to make sure they're compliant, whether it's federal law that you need to follow or your state's law. Implement procedures for evaluating how changes to job duties or conditions will affect the classification of a particular worker, and consult an employment attorney in your jurisdiction to help you with all of this. And of course, maintain documentation that support your decisions on this. I'm always going to say that. Document, document, document for everything. So here's another poll. Well, we're at the halfway mark. We're only about a third of the way done, so I'm gonna have to speed things up a little. But which factors would you consider to avoid legal trouble? So you're hiring a new worker for your New Jersey. Let's focus just on New Jersey for the purposes of this poll. Your New Jersey company, you need to decide if they should be an employee or an independent contractor. So what factors should you consider? A is how much control the company has over the worker's tasks and schedule. B is whether the worker performs services outside the company's usual business operations. C, if the worker is running their own business and offers services to other clients. Or D, all of the above. Let's see, are people?
Yeah, all D's so far.
Well, that's good. That's correct.
Okay,
I'll move on. Everybody understands this. This is, yeah, the ABC test. I think this was a giveaway. Okay. So next topic, little segue. How can employers legally stop their employees from poaching their clients and other employees? Now, you may have known that back in April, the Federal Trade Commission issued a rule banning non-competes nationwide. That rule has since been stopped, right? A federal court in Texas said, nope, we're going to issue an injunction, which means you can't enforce this rule anymore. So non-competes are still alive. They survive. But you still need to be careful and because it's now up to the individual states, as many of our laws are now, unfortunately, but every state may be different, and some states are trying to crack down. New York and New Jersey have been proposing laws to restrict non-competes, not as much as the FTC was, but none of them have actually passed. Well, actually, New York's law passed, but the governor refused to sign it, so it didn't become law. That may be revisited in both those states' legislatures. So we'll see what happens with that. But in the meantime, I recommend that you focus more on non-solicitation agreements and confidentiality agreements, but I will get to non-competes too. Um, a non-solicitation agreement prevents employees from soliciting clients or other employees. They protect client relationships and internal talent. If properly drafted, they clearly define what's prohibited and the time frame for it. To be legally enforceable, they must reasonably protect the company's legitimate business interests without being overly broad. Um, I won't get into all the details about, how to draft these agreements, but that's a legal consultation. But just to give you an overview, confidentiality agreements are a little different, and they can be more broadly used. They're essential to protect sensitive business information from unauthorized disclosure, but keep in mind that business needs to protect that information too. So if the business is letting this information leak out, then it's not confidential information. So the agreement must clearly define what is confidential information and what are the worker's obligations or the independent contractor. So this confidentiality agreements, you can use these with independent contractors. Non-solicit is a little tricky. You probably could. Non-competes, you can't. Duration of confidentiality obligations certainly would extend beyond employment or engagement, often lasting several years, if not indefinitely. Most confidentiality agreements I see are indefinite. Like you can never disclose this stuff unless it becomes public information, then that's different. Employees and independent contractors must be educated on the importance of maintaining confidentiality so that there's a culture of compliance and so that confidential information really is confidential, and can be protected by these agreements. So a word about non-competes. They should be used sparingly, only for positions that, you think if they go and work for your competitor, they're going to harm the company and, take business away from you. They need to be reasonable in scope, meaning they shouldn't excessively restrict an employee's ability to find new work. Scope could be geographic, it could be time, could also be like, well, you did this type of work, so you can't do that type of work for a competitor. But if a competitor does something different from what you did, then maybe that would be allowed. They really should be narrowly tailored. Duration should be limited. Typically, I say 3 months to a year, depending on the industry and the jurisdiction, would be enforceable. Geographic limitations should also be clearly defined. These days, it's difficult because, lots of companies do business nationwide or even internationally. But if you can focus on areas where the business actually operates and or has a significant presence, that's better. And it shouldn't impose an undue hardship on the employee's right to earn a living. That's where the FTC comes down on these agreements. And they're still going to be coming down on agreements, even though there is no longer a nationwide ban. Audit these regularly, right? Conduct audits of them, make sure they comply with current legal standards. And, look, this will help you identify outdated or overly restrictive clauses that may not be enforceable. So, another poll. Your top sales executive just resigned. And just by the way, sales people are ones who I would say, non-competes could be enforceable against them. They're out there getting sales for your company, right? You don't want them competing. They have strong, especially when they have strong relationships with your largest clients, like in this scenario. You also suspect they may try to lure away key employees. So what's your strategy to protect your business? A, enforce a non-compete agreement and ensuring they can't work with competitors in your region for the next year. I'm just assuming your non-compete restricts them for 1 year. Rely on the non-solicitation agreement to stop them from reaching out to your clients and employees, or just count on the confidentiality agreement to protect you, or all of the above. What do you say?
Okay. We have, let's see. Oh, B and C, D, D, B, D, D.
I
What do
think
you
it
think?
depends on your industry if you're going to enforce a non-compete agreement or even have a non-compete agreement with your salespeople. Depends on your industry, depends how competitive it is. A year may or may not be enforceable again, depending on those factors. So yes, it could be all of the above, or it could be just B and C. I would definitely not just count on confidentiality agreements for sales executives. That's not going to cut it. For other types of employees, yeah, sure. Like an administrative assistant, you don't need a non-compete. You don't need, probably don't even need a non-solicitation. A confidentiality agreement is sufficient. So now we're going to do some fun stuff. Do's and don'ts of social media in the workplace. Understand that social media can significantly influence workplace culture and employee behavior. Clear guidelines and understanding the implications of online activities are essential to maintain a professional environment that protects the company as well as its employees and, I'll say, independent contractors, because they could, be involved in this too. So the first step is uh, to protect everybody from social media. I hate to say that, but that's the case these days. Establish and enforce clear policies. Make sure you have a comprehensive social media policy that outlines acceptable behaviors and practices and includes guidelines for both professional and personal account usage related to the company. Specify disciplinary measures for policy violations so that you can reinforce accountability and ensure that your employees and independent contractors acknowledge and understand the policies during onboarding and regular training sessions. Now, I want to talk about off-duty activity because New York is one of the states that has a law about that. You have to be careful. There may be things that employees post on social media in their own on their own time, on their own personal page that could impact the company. Um, its reputation, employee relations. I mean, it depends on what they're posting, right? It could influence perceptions about the company and other employees. If they're posting confidential information, they're posting medical information about an employee. If they're saying outrageous things that and identifying themselves as an employee of the company, that could harm the company. And then it's okay to discipline them, right? If they're talking about terms and conditions of employment and they're not a supervisor, then under federal law, under the National Labor Relations Act, they're allowed to do that. So there's a fine line there. And New York, you have to be careful because New York does regulate what employers can do regarding off-duty conduct of their employees. And it's really only if it's something they're doing on social media that could harm the company or the company's employees. And so you need to be aware of that too. But again, your policy, should state like, look, if you wouldn't say this to your grandma, don't put it on social media, right? You want to maintain a professional atmosphere and, or say, this is my personal opinion, has nothing to do with who I work for. And, most people's social media profiles have their employment listed there. So it could be a problem. So this is a little tricky, this poll. So I think so. I'm going to give you this scenario. An employee posts a controversial comment on their personal social media page over the weekend. I'm not explaining what that controversial comment was, but you can imagine there was a lot of this going on during the Black Lives Matter protest, during COVID, and even, now we have a presidential election coming up. There's a lot of vitriol on social media about that. And even, anti-Semitism, the whole Middle East conflict, Ukraine. I mean, anything and everything, right, going on politically could be subject to a controversial comment on social media. And it's their personal social media page, right? But it catches the attention of your company's largest client. And they're upset about this. So what do you do as an employer? And this could be any combination of approaches or all of the above. Refer to the company's social media policy and take immediate disciplinary action for violating guidelines. That's A, choice A. Choice B, Schedule a meeting to discuss the post and remind the employee of their professional responsibilities, even off duty. C is encourage the employee to issue a public apology to manage the client's perception. D, use the situation as an opportunity to provide additional training on appropriate social media behavior and the company's expectations of its employees and its independent contractors. So, or all of the above. So what does everybody think?
Are you grading this on a curve? Okay, good.
No grades here. This is pass fail.
Okay. Okay, we have
So
a
far, everybody's passed, I think.
we have we have a BD, we have an E, we have a BCD so far.
Okay.
A
So
D,
people are a little, sounds like people are leery of,
BD, another BD.
okay, so no A's. Okay, so it sounds like people are leery of imposing discipline for violating company guidelines. I don't, if it's egregious enough, I don't think you should hesitate to do that. But again, it depends on the circumstances. And certainly, yes, if you can, you know, discuss it, a first step, discuss it with the employee, you know, remind them of their, um, you know, professional responsibilities, even off duty. I love the one about, you know, encouraging the employee to issue a public apology. The employee may not want to do that, but certainly the company should, right? The company, if it's that, if the, especially if the company's largest client is that upset about it, others are too, and maybe not voicing it, put something out there on social media. Look, this is not, this does not represent our company's position on whatever issue it is. We don't have a position, we don't take political positions, or whatever the case may be. You know, again, it doesn't have to be the employee issuing the apology or the explanation, but the company can do that. And, you know, keep in mind, it would be more egregious if this employee is the one who is the designated employee or one of the designated employees to post things on social media for the company. That would be worse. And you need to have guidelines around that as well, obviously. And yes, always use these situations as opportunities for more training. These are great, you know, a great example for that. So I think I have, wow, okay, I'm gonna go through this quickly because I think I have two more topics to cover. We're gonna talk, I wanna tell you how to accommodate employees with disabilities. I'm going to go through this relatively quickly. First, you want, when you can, provide reasonable accommodations. Now, reasonable means that it's not causing an undue hardship to the company. And there are all kinds of factors to look at for that. But when you can, adjust work environments to fit individual needs, such as accessible entryways, workstation adaptations, allowing an employee who has to stand most of the time, maybe give them a high stool so they can sit if that's what they need. Use appropriate assistive technology such as screen readers, hearing aids for screen readers for people with vision issues, hearing aids, obviously if someone has a hearing problem. Allow flexible work hours or remote work if you need to accommodate an employee for their medical appointments, physical therapy, or if their energy tends to fluctuate. Again, all within, you know, the job responsibilities. As long as they can do the job with or without a reasonable accommodation, you have to, you know, provide that if it's reasonable. Again, it has to be, the accommodation has to be reasonable. It doesn't have to be the employee's first choice. But companies, and again, the smaller the company, the harder it's going to be in terms of the expense to the company to do certain things, but you do what you can. Sometimes, you know, you may want to reassign the employee to maximize their strengths and capabilities without, as long as you're not compromising the company's needs, right? That's always a factor. The one thing that is really, really important that I've seen so many companies fail to do is engage in what's called an interactive dialogue with the employee. Once an employee, not before, you don't want to assume an employee needs an accommodation because that could be discriminatory. But once an employee requests an accommodation, initiate that conversation, that discussion about what do you need, and then look and see, you know, what can we do to help that, to help you with that. You want to foster an environment where employees are not, you know, afraid to come forward with these types of requests. And be collaborative, assess what potential accommodations you can provide that balance the employee's needs with the company's needs and their resources. And then even after you provide that accommodation, check in regularly with the employee, make sure it's still working, right? And also make sure they're still able to do their job with that accommodation. Because if not, maybe they need something else, or maybe it's time to let them go or put them out on leave, or, there are all kinds of options. Also address safety concerns, particularly with disabled employees. Make sure that you have an action plan for emergencies for everybody, but in particular, someone who has disabilities, right? If they're physical disabilities. Ergonomic assessments are helpful as well. Train your staff on the importance of all of this and regularly review your safety protocols. And then, of course, document the accommodations, but these documents need to be kept in a separate file, confidential, and need to know only gets to see this, because that's first of all under the Americans with Disabilities Act. That's a requirement, but you also want to protect your employees' privacy. So another poll. Let's see. You've just been informed that an employee requires certain accommodations due to a disability. After discussing their needs, you implement the agreed on adjustments. However, a few weeks later, the employee mentions that the accommodations aren't working as well as expected. So what's your next move? A, revisit them with the employee to explore further adjustments and improve effectiveness. B, suggest they seek external support like assistive technologies to enhance their work performance. C, document the feedback, consult with HR and/or legal teams, and develop a new plan that better fits the employee's needs. Or D, assume that the current accommodations are sufficient and advise the employee to adapt. I didn't have all of the above, but you could choose E, all of the above, if you want. Let's see how well you do here.
Okay, we got an A and C, an A and ABC, an A and C.
Okay, A and C, yes, definitely either one or both. You may want to try, working with the employee first, but then if you need the help of HR or the legal teams, obviously do that, and certainly document everything. So B, I'm going to disagree with. I'm going to say no. You don't want to suggest that the employees seek external support. The company should be providing that. Again, unless these assistive technologies are really expensive and the company can't afford it. You have to do a cost benefit analysis there. But don't put it on the employee. It's really up to the company to do what they can. And D, obviously everybody recognized, assuming everything's fine when the employee complained, like, no, that's a no. So I believe this is my last topic, which is good because we only have about 10 minutes to go, but I will stay I see there are, these are all the answers to the polls. I see there are a lot of things in the chat. Hopefully some good questions too, but let me talk about how to investigate a discrimination or harassment claim. Proper investigation of these types of claims is critical to maintaining a fair and compliant workplace. You want to ensure a couple of things: confidentiality, prompt action, impartial evidence gathering, and effective corrective measures to mitigate risks and demonstrate that you as the employer, if you're the employer, have a zero tolerance policy against discrimination and harassment. So begin your investigations immediately, as promptly as you can. It signifies that the company is serious about this. It helps preserve evidence, and delaying could lead to further incidents and damage the company's reputation. Confidentiality is really important to the extent practical and possible. Employees are allowed, lower level employees, non-supervisory employees are allowed to talk about this stuff amongst themselves, but you want to encourage them not to, but you can't require them. But higher level people, yeah, everything should be treated as with the utmost confidentiality. You're protecting the participants and you're protecting the integrity of the investigation. Only those with the need to know should have access to the information, and obviously your documentation should be safeguarded. Gather evidence thoroughly and impartially, and don't forget, not just interviews, don't forget, and documents, paper documents, don't forget electronic documents, photographs, text messages, social media posts. video and audio recordings, any physical evidence that might be related to the complaint. Ensure the interviews are conducted without bias. I often recommend, and I do these investigations, but I don't do them for my clients because then I would be a fact witness and then I can't defend them if there is a lawsuit. But I do them for others, other companies who are not my, not my employment law clients. I do it as an investigator. I wear my investigator hat, not my lawyer hat, not my attorney hat. Neutral, unbiased investigations are key. So often companies should hire someone outside the company to do that. Internally, could be biased. And document, like I say with everything, always document the investigation. So you want to report at the end so you can substantiate the findings, and then make sure you take action, right? What was the point of doing the investigation if you're not going to do something about the behavior? Now, maybe it wasn't substantiated. Well, maybe you still need to do some more training. Just implement the necessary actions and communicate clearly to all the parties involved what you're doing and what the rationale was. And then monitor the workplace post-investigation to make sure that there's no retaliation for having participated in the investigation and that there aren't any further incidents. I'm going to skip this poll. Let me see. Yeah, I mean, I will just say, well, this is a tricky one. Let's do this. I like this one. Sorry. You are investigating a discrimination claim. The accused employee has a history of stellar performance and is highly valued in the company. That often happens. During the investigation, the complainant reveals that they don't want to escalate the situation, but they still want the behavior addressed. So what should you do? A, document the situation privately and issue a verbal warning to the accused. Proceed with the full investigation to ensure that any inappropriate behavior is addressed thoroughly and transparently. C, offer both parties mediation to resolve the matter informally and avoid a formal investigation. Or D, conclude the investigation quietly without any further action. So what does everybody think?
Let's see.
And like I said, if people can hang out, I will answer your questions. If we have to go over, I'm good with that. Whoever has questions and wants to hang out to hear the answers.
Got a few A, B, A and B,
Okay,
and maybe C.
okay. So good. Nobody chose D, which is good. I'm not so sure about A. I don't know that that's enough. I think B and C are, I like C a lot. I like, that could be a way to resolve it informally. Once an employee complains about bad behavior in the workplace, employees are obligated to investigate. It doesn't matter who it is. And even if the employee says, well, I don't want this to be a big deal, but, right? Well, you complained, it's an issue for you, we need to investigate. And whoever's doing the investigation needs to explain that to them. And no, no one's allowed to retaliate. You're not going to lose your job over this. And if you do, well, no, we won't let that happen at this internal level. That should not happen. Unless there's another reason they need to be let go, which we covered earlier. Okay, so I just want to do a very quick recap. So far, you've discovered how employers can help avoid a lawsuit when they fire an employee. I listed a couple of things here to do. And also you've learned what factors employers must consider when classifying workers as independent contractors or employees. I reiterated the ABC test here. And now you know how employers can legally stop employees from poaching clients and other employees, and the do's and don'ts of social media in the workplace. We also talked about how employers should accommodate employees with disabilities, particularly by providing reasonable accommodations, and how employers should investigate a discrimination or harassment claim. We just talked about that. So here's what I truly want you to understand. Employers who know how to comply with employment laws and do so are more profitable and then everybody wins. So in order to make that happen for you and your client or clients, I'm offering you a confidential, complimentary 15-minute Zoom meeting to answer your or their one burning question. And of course, you'll have an opportunity to ask questions here, but obviously I'm not going to give 15 minutes to each question. It'll probably be 10 minutes for all of them. If you'd like to do that, give us a call and you'll get a copy of these slides too. But if you want to write it down, 973-787-8442. Speak with I have two intake specialists or my legal assistant is Julie, my paralegal is Carrie. And you can schedule your confidential complimentary 15-minute Zoom meeting with me. It'll be with me. I will let them know that, this is happening. So we're up to, wow, all right. We got a couple minutes Q&A. Good.
Okay, a few questions. David, you had the first one back in near the beginning. That individual.
It's me, right?
Yes,
Yeah,
you
am I in trouble here, David?
No. I was interested in the ABC test, actually, in New Jersey, because, frankly, because of both the way financial advisors tend to be hired, as well as, I'm just going to use the example of realtors.
Yes.
So are you going to tell me that all realtors in New Jersey are W-2 employees? Because I don't believe you.
No, you're absolutely right. That is an exception that I failed to mention. Financial advisors have very unique arrangements. They're like, yeah, they can be independent contractors, even though that's the core business. Yeah, they are the exception, as are realtors. So those are the only two exceptions that I'm aware of. So you're absolutely right, David. Yes.
Thank you, because I was
You're
worried.
welcome.
Okay, the next one, Nazgul, am I pronouncing that right?
Yes, thank you.
Okay.
My question is whether there are any protections for employees in their social media posts in terms of disparaging their employer. So that's my question. And then related, well, not related, unrelated, I want to know, in our follow-up question with you, could we ask about topics not covered at all today?
Oh, absolutely. I'll answer your second question first. Yeah, absolutely. Could be any question about employment law, as long as it doesn't involve too much about, I'm not really, I don't deal with unions and don't deal too much with benefits. Yeah, that's fine. The first question about, I'm sorry, protections for employees who disparage their, say, supervisors. That was the question? Okay. So if the employee is a non-supervisory employee, then under the National Labor Relations Act, they're allowed to discuss with their coworkers terms and conditions of employment. So if what they're, if they're saying I have a terrible boss, right? And they're posting that on social media, they're allowed to do that. You can't really discipline them for that. But if it's a supervisor, you could discipline a supervisor for saying that, like, oh, my CEO stinks, right? That you could, because that could damage the company's reputation. So it really depends on who the employee is, what level they're at. But yes, they're protected. I mean, that would be considered if they're saying, this company is really stingy, they're not paying me enough, right? I can hardly afford, to live on, it's not a living wage, right? I can't live on my salary. And yet they're spending all this money on all these ridiculous things that aren't important but not paying me enough, right? Again, if it's a non-supervisory employee complaining about that on social media, that's fine. Yeah, you kind of have to let it go. And it is what it is. Companies have to deal with that. And there is protection for employees about that. I hope I answered that.
Thank you.
Thank
You're
you.
welcome.
Okay, Amy Jo.
Hi, yeah, and maybe you said you don't deal with benefits, so maybe I was just inquiring about, what benefits a small employer or less than 10 employees obligated to provide. And, I hear a lot about, oh, you don't have to do it, but you might want to. Are there best practices?
Okay. I can answer that to a certain extent. Small employers are not required to provide health insurance, at least not yet. They can, and there are small employer plans. I just happen to know about that because I have one from my firm. Um, um, truly the only benefit in New Jersey, I'll say New Jersey, and is well, obviously, you know, all the, you know, Social Security, Medicare, all the deductions that come, you know, by law have to come out of paychecks, right? Sick time, it's the paid sick leave, paid family, well, paid family leave, but it's from the state, it's not from the employer. You know, family leave, paid disability leave. Again, that's paid by the state. Employees and employers contribute to that through payroll. These are all benefits. You know, time off, you know, to care, you know, like I said, mostly it's sick leave. And again, it depends on the size, how many employees the company has, what they're required to do, both in New York and New Jersey in terms of paid sick leave. Particularly New York, New Jersey, it's pretty much across the board. Everybody has to provide paid sick leave.
And is there a limit? Can you put a cap on that?
It's 40 hours. It's 1 hour for every 30 hours worked, up to 40 hours in a calendar year or a benefit year, depending on how it's designated. And that can be carried. You have to carry it over, but you don't have to give more than 40 hours in any given year, benefit year. So the carryover is sort of, it's only if you're doing it on an accrual basis and they haven't earned it. Let's say in January, an employee is sick and they haven't earned their time yet and they need it. If they didn't take all of their time the previous year, they can take some of that before they earn it for that next year. But then, you know, for that year, but then they're still capped at 40.
Got it. Okay. Thank
But you don't have to provide vacation time again. It's, you know, it's a good practice to give employees vacation time. I just think, you know, look, employees need a break from work, right? And, you know, paid vacation makes a big difference for people, I think. But how much you provide, that's up to you in New York and New Jersey. Now, California is a whole different story. I don't practice there, but yeah.
Yeah.
Thank you.
I have a quick question about non-compete agreements.
Yeah.
If you're hired by a company and they want you to sign a non-compete and you read it and you see this is like so onerous, you know, you can't do anything that relates to us for the rest of your life or whatever. Are those things redlined by, you know, like in New York State or New Jersey, so they don't throw out the entire agreement, but they just say, okay, this part is reasonable and this isn't?
Yes. And actually it's called blue lining, but yeah, I'm sorry, not blue lining, blue penciling. Yeah, blue penciling. Close. Yeah, judges will do that in New York, New Jersey. Yeah, they'll blue pencil an agreement if they think it's too broad. Yeah, they will definitely do that. And look, I recommend that, you know, when someone's accepting a new job, that's the honeymoon phase and they don't want to rock the boat. They may not want to try to negotiate some of the terms. I recommend that people do that. I do work with high-level executives and professionals and help them negotiate these things at the front end, at the back end. It's better to do it at the front end and, you know, get it, you know, if it's too broad, push back, I think.
Yeah,
you know,
but doesn't it still have a chilling effect because the employee would be going against maybe a large employer that has deep pockets, and
Sure.
if you violate the agreement, they might sue you anyway, knowing that they're going to lose, but you'll back down.
Yeah, that's why I recommend negotiating at either scenario, either at the front end before it's a problem or at the back end when you're leaving. You know, it's going to be much less expensive to try to negotiate your way out of it. Sometimes you can get your new employer to work with you on that because they don't want to be sued either. The worst thing you can do is violate that agreement and, you know, take that new job. You know it's violating the agreement. Or just being oblivious about it, and it turns out you're violating, because then you could lose that new job, that brand new job that you just took, and be sued in court. Yeah, it's a problem.
Okay.
I don't know if you see Jonathan. Rose Kaz raised her hand.
Who?
Rose K-A-Z.
He had to drop off.
No,
Oh,
I'm
she-
here.
Oh, yeah,
here.
Rose Cass.
Oh, there she
Oh,
is.
Rose Gas out there.
Yeah, she was asking for the phone number again,
I
Okay.
which
I have-
Actually, I'm gonna put that up. There it is.
have a question, if I may. if
Oh.
time-
sure.
Yes.
Thank you so much. This has been really helpful. In regarding rather documentation from a supervisor that is one-sided, meaning like the employee was not made aware of breaches of company policy, et cetera, and then was fired sort of out of the blue, without HR present or witness present at the termination. How does that documentation stand up? As you know, because I keep hearing you say document. Does it become sort of a he said, she, or, hearsay kind of thing?
Yeah, it would. I mean, I think that's a mistake on the employer's part, not to give the employee warnings, and not to, you can employers can discipline employees without firing them, right? There should be, I think, progressive discipline, unless it's something so egregious that you just have to fire them because it was so bad what they did, but you still should be telling them what did they do wrong, right? Maybe there's an explanation for it. But I mean, some things I guess there may not be an explanation for, but yeah, I think if the employees should be aware of what the company's policies are and should be, adhering to them, but things happen and employees make mistakes. And I think that's a mistake on the part of the employer. The problem is, unless this employee's in a protected category and unless the employee can show that somebody else did something similar and wasn't fired, who, let's say it's a black, I'll just use an extreme example. Let's say the employee is black and a white employee did something similar and wasn't fired. The black employee was fired. Or let's say it's a woman and a male employee did, similar situation. Well, then they have a potential legal claim against the company. But if they're not in a protected category, if they can't prove that they were fired because of their protected characteristic, whether it's age, race, sex, whatever it might be, it's going to be a hard one to do.
And what if the reason for termination was so general and broad, like not you did this thing or the series of things?
You're not a good fit is a very common phrase that
Yeah.
employees use.
And
You're not a
is
good fit. It's just not working out. Again, unless they can point to, well, you did this because I'm blue, black, or orange, it's going to be a tough one to prove. I mean, in New Jersey and in New York and a lot of other states, employment is at will, which means employees can be let go for any reason or no reason, as long as it's not for an illegal reason. And employees can leave too whenever they want. Most employers, request notice, but employees don't have to give notice. The only thing they often lose if they don't give notice would be like accrued unused vacation pay, if that's in the employer's policy.
Okay, thank you. Rachel, you have your hand up.
Yes, you partially answered this question with regards to benefits that small companies offer, and kind of the long-term success of a small business. It behooves us to provide these benefits, et cetera. But more broadly, I was wondering, are any of the kind of regulations, sorry, I'm getting pop-ups, applied only to larger companies? For example, if it's less than 10 employees, while there is a human or a humane aspect, do we need to do all of the investigations and training, et cetera, to prohibit negative legal action if/when we lay someone off?
Well, I mean, I think, so you're talking specifically about when you lay someone off or in general?
My question is pretty broad. So in general, yeah.
Okay, in general, yeah, as a smaller company, you may not need to do, the kinds of trainings that larger companies need to do. Training's always good though. I mean, but it could be informal, right? It could be, buy everybody lunch and eat in the lunchroom or the conference room or whatever, bring lunch in and let's talk about, how to behave, right? And it may not be necessary, right? If you know your employees well and they're all getting along, and you may not need to do training, but just, even small companies have problem employees, right? And so once, an employee's, not performing well or engaging in inappropriate behavior, you need to address that, and you sit down with them privately and then document, that meeting. And then that way you have your paper trail if and when you do need to fire them. And then, yeah, I mean, if you can, it's always good to offer severance, because then in exchange for a release of any potential claims, it's always good to do that, but offer a minimum amount, 2 weeks, and again, depends on the level of employee as well. But I think in terms of, terminating employees' employment, you should follow those protocols. In terms of doing workplace investigations, look, if someone complains, like, do an investigation. I mean, but it could be less formal if you're a smaller company.
Okay, that makes a lot of sense. Thank you so much.
Sure.
Okay, so we have one, let's make this the last question, and
Okay.
then we'll thank Alex, because I know she has to go. Nazgul and then Sally. We'll have 2 quick ones. Keep it.
Thank you so much. I'm wondering how it would, when wanting an employee to leave, but preferring not to fire them, is it legal to assign them responsibilities that would encourage them to leave?
Yes, this happens a lot, actually. I've seen it a lot. Look, it's not illegal to do that. I don't know that it's a best practice, quite frankly. I think it's better to just be honest about, like, look, what's going on with you? Are you happy in your job? We don't think it's working out. Is there something else? Are there different responsibilities that you think you could succeed better at? Right. But if the employee's if it's a toxic employee, if they're hurting your work environment, then you just say to them, here's why, you did this or that. It's better to be specific rather than just say you're not a good fit anymore. Right. Because that leaves employees wondering, like, oh, this might be discriminatory. I should file a lawsuit. Right. And then, let them collect unemployment. I always say that, unless they quit, Yeah, I mean, I don't like that tactic at all, of giving them a job that they're going to hate and they'll leave. But and then say, okay, we want to ease your transition. We'll give you X number weeks of severance just to ease your transition. You want to be humane about it. What comes around goes around. That's how I see it.
Thank you. Okay, Sally, last question.
Hey, yeah, I just had a couple of comments and then a question. So when you were talking about the independent contractor versus employees, what I find with some of my small business clients, they tend to use the word employee in speaking of the people that provide out services. So I usually tell them to not use that term. And yeah, and you didn't mention that. Also, the other thing I wanted to mention, if your clients have a professional employer, like a PE, like, ADP,
Oh, a PEO.
that they will do some of that, like the investigation for harassment and that kind of thing. If they do, I'm not trying to get somebody.
Oh, some do that. Some payroll companies have an HR wing that does them, or has certain HR functions. Yeah, I don't know how effective PEOs are with workplace investigations, but if they're trained workplace investigators, sure.
Yeah.
I just know, as having done quite a number of investigations, that and seen other investigators, when it's someone who's really, really knowledgeable either about HR or an employment attorney, that they're They're going to be better. You know I use my expertise as an employment attorney to help me, even though I'm not acting as an attorney, I'm not giving legal advice when I'm doing an investigation, but it really helps to kind of know to know the law and to know.
That's, yeah. And then you said something about let them collect unemployment. Can you keep a former employee from being able to collect unemployment?
Yes, if you allege that, number one, they quit, if they quit, if you didn't, if they quit on their, and not because you told them to leave, right? But if they quit, then they are not entitled to unemployment. During the pandemic, it was different. Everybody was entitled to unemployment, but not, now we're back to the quote unquote normal times.
So they're not entitled.
But
Is that
also,
in all states, including New York?
I don't know all states. I don't practice in all states. New York and New Jersey, that's true. Also, if they engaged in really, really severe misconduct, then they, but the employer has to challenge their claim. You would have to go to the hearing.
You would have to
like
fill that form out to say, because you get, as the employer, you get a form as well when somebody claims, and then you can say all that then, and maybe
and then you get called.
But if they quit, I wasn't aware of that. Okay, thank you.
Yes, you want to put that on the form that you get, that they actually quit, therefore they're not entitled.
I guess that's one of the questions, actually, come to think of it. Yeah. Okay. Thanks so much. Great presentation.
Oh, thank you. Well, one other point I wanted to make. When employers let people go, they do need to provide the employee with and fill out their part of the form. There's a form. It's on the New Jersey. I'm not sure about New York, but New Jersey Department of Labor website and you have to provide the employee with that form so they can apply for unemployment.
Okay. Well, I'm not sure. In New York, usually it seems like the employers gets the notice from New York.
We do here too. We do here too. Then they send when the employee makes the claim. And I think in New York, the employee just goes online and makes the claim.
Yeah. Okay. Thanks again.
Thank you very much, Alex. Thank you so much. And thanks for staying later.
No problem.
I'm going to turn off the recording. And